Chapter 2. Subject Matter Jurisdiction of the Federal Courts. Key Exam Issues. Like personal jurisdiction, subject matter jurisdiction is covered in most civil procedure courses. Although the topic has the same title, jurisdiction, and like personal jurisdiction deals with a court's power to hear a case, it relates to a very different concern and should be kept separate. Rather than focusing on the geographic location for litigation, subject matter jurisdiction usually concerns whether a type of case may be brought in federal court. In every state, there is a state court of general jurisdiction. This means that cases of any type may be brought in that court. Thus, the term general jurisdiction means something very different in regard to subject matter jurisdiction than it does concerning personal jurisdiction. Federal courts are courts of limited subject matter jurisdiction. Article Roman III of the Constitution does not create any lower federal courts, although it permits Congress to do so. Also, Article Roman III limits the sorts of cases that Congress could authorize the federal courts to decide, requiring that they be courts of limited jurisdiction. There are two main constitutional headings of federal court jurisdiction: diversity jurisdiction and federal question jurisdiction. Diversity jurisdiction is authorized by the Constitution whenever there is a party on one side of the litigation, plaintiffs, who is of diverse citizenship from a party on the other side of the litigation, defendants. Federal question jurisdiction is authorized when a claim arises under federal law. The first Congress created lower federal courts and assigned them jurisdiction over certain cases. Since then, the statutory grants of jurisdiction have been modified, generally to expand the federal court's authority to hear cases. But the statutory grants of jurisdiction are usually interpreted to be narrower than the maximum authority the Constitution permits Congress to assign to the lower federal courts. Accordingly, when you have an examination question about the subject matter jurisdiction of a federal district court, it is important to focus on the following statutory grants of jurisdiction. 1. Is jurisdiction available under the General Diversity Jurisdiction Statute? A. Complete diversity. Under the statute, there must be complete diversity. This means that no plaintiff may have the same citizenship as any defendant. For this reason, you will need to determine the appropriate citizenship for each party to the case, even if there are numerous parties. Keep in mind that some of those parties may be regarded as citizens of more than one state for purposes of diversity of citizenship. For example, corporations have the citizenship of every state in which they are incorporated and also of the state in which they have their principal place of business. Other groupings of people, such as partnerships or labor unions, may be considered to have the citizenship of each of their partners or members. B. Jurisdictional amount. The diversity statute also requires that there be more than $75,000 in controversy for jurisdiction to be available. If the plaintiff has claimed more than this amount in the complaint, this question ordinarily involves determining whether the claim was made in good faith. If the court can say to a legal certainty that this amount could not be recovered, this requirement is not satisfied. C. Do special jurisdictional provisions apply to this case? For some types of cases, special jurisdictional provisions may apply. Certain class actions may be brought in federal court on grounds of minimum diversity. Similarly, interpleader actions may be brought in federal court on minimal diversity, i.e., one plaintiff who is diverse from one defendant grounds. 2. Is jurisdiction available on the ground that the suit raises a federal question? A. Federal claim. If the plaintiff is asserting a claim created by federal law, this ground for jurisdiction should be satisfied. The claim may be expressly created by federal statute or implied by federal courts for violation of a prohibition in a federal statute. Even if the federal claim is subject to dismissal for failure to state a claim, it suffices to support federal subject matter jurisdiction unless the court finds that it is wholly frivolous and made solely to obtain federal jurisdiction. B. State law claim raising federal issue. Even if the plaintiff is not asserting a claim created by federal law, there may be grounds for federal court jurisdiction if the assertion of a state law claim turns on the resolution of a federal issue. Assuming the complaint alleges a federal issue, the question is whether it meets the well-pleaded complaint test, i.e., whether the inclusion of the federal issue is necessary as a matter of pleading to state a claim. Thus, plaintiff's anticipation of a defense based on federal law that defendant is certain to raise is not sufficient to establish federal court jurisdiction. Also, if the federal ingredient is necessary to a plaintiff's claim, the federal issue must be substantial, because the determination of the state law claim turns on resolution of the federal issue, and it may be important to ask whether there is a federal interest in having the claim in federal court. 3. If the case was originally filed in state court, have defendants properly removed it to federal court? In general, defendants may remove the case to federal court whenever the plaintiff could originally have filed the case in federal court on grounds either of diversity or federal question. In a sense, this means that there is a preference for adjudication in federal court since the case will be heard in a federal forum whenever one side wants it in federal court. Thus, often a question about removal jurisdiction asks you first to address the issues raised above, and then you must consider some specialized aspects of removal. A. Timely notice of removal by all defendants. There is a short time frame for removing a case to federal court, and all defendants must usually join in removing the case. B. Whether case was within federal court's original jurisdiction. Defendants ordinarily may remove the case only if it would have been within the federal court's original jurisdiction had plaintiff filed it in federal court. But note that sometimes this is not sufficient. For example, even if there is complete diversity of citizenship, removal is generally not available on grounds of diversity of citizenship if one of the defendants is a citizen of the state in which the suit was filed. C. Alternatively, whether case involves a separate and independent claim arising under federal law. In one situation, removal jurisdiction is broader than original jurisdiction. If a defendant is sued on a claim arising under federal law that is entirely separate from the other claims asserted in the case, it may remove the case on that ground even though plaintiff could not initially have filed the case in federal court. D. Once removed, whether case is subject to remand to state court. If the case was improperly removed to federal court, the federal court may remand it. Even if removal was initially proper, if all federal claims have been dismissed, or if plaintiff was allowed to amend to add non-diverse defendants in a diversity case, the federal court may remand. 4. Can supplemental jurisdiction be used to add claims or parties to the case? When a claim is properly before a federal court, the court may have supplemental jurisdiction over additional claims against existing parties or against additional parties. If you are presented with such additional claims or parties, consider the following issues. A. Constitutional limits of federal judicial power. The federal court may exercise jurisdiction over the additional claims only if they are part of the same constitutional case, which usually depends on whether the additional claims arise out of the same common nucleus of operative fact as those within the federal court's original jurisdiction. B. Special limits on supplemental jurisdiction in diversity cases. To safeguard the complete diversity requirement, supplemental jurisdiction is limited when plaintiffs want to use it in cases that fall within diversity jurisdiction. Thus, supplemental jurisdiction cannot be used to add claims by plaintiffs against any non-diverse person made a party through third-party practice, joinder of necessary parties, permissive joinder, or intervention, or over a claim by a non-diverse person sought to be joined as a necessary party or intervener. C. Discretionary decline of jurisdiction. Even if supplemental jurisdiction is authorized by statute, the district court has discretion to decline to exercise it due to the complexity of state law, because the state law claim substantially predominates, or because the court has dismissed the claim over which it had original jurisdiction. A. Introduction. 1. Nature of subject matter jurisdiction 284. Historically, sometimes by mere accident, the courts obtained authority to decide only certain types of actions, i.e., they had jurisdiction over only particular subject matters, e.g., only cases involving claims in excess of a certain amount of money, or only claims involving land. Thus, whether a court has authority to hear a particular case may depend on the subject matter involved. The most significant limitations on subject matter jurisdiction today, for purposes of this summary, involve the subject matter limitations on the federal courts. These limitations often reflect notions of the proper relation between federal and state power. 2. Personal jurisdiction distinguished 285. Subject matter jurisdiction differs from personal jurisdiction. Personal jurisdiction limits the power of courts over persons based on geographic location. Subject matter jurisdiction limits the power of court based on case type. Subject matter jurisdiction allocates authority between court systems, e.g., only courts in the federal system have subject matter jurisdiction over admiralty cases, or among courts of a given system, e.g., some states provide that only state family law courts have subject matter jurisdiction over divorces. The two concepts of jurisdiction should not be confused. It is incorrect, for example, to say that the court has diversity jurisdiction over the defendant because diversity jurisdiction refers to jurisdiction over the type of case, not over the defendant. To proceed with a case, the court must possess both personal jurisdiction over the defendant and subject matter jurisdiction over the claim. 3. Defects not waivable 286. Lack of subject matter jurisdiction is not waivable, so it may be raised as a basis for dismissing a case at any time. It can lie in the background as a sort of time bomb in the plaintiff's lawsuit. A. Plaintiff must allege grounds for subject matter jurisdiction 287. Ordinarily, the plaintiff must include in the complaint allegations stating the subject matter jurisdiction of the court. CFED R. Civ. P. 8A1. B. Defendant may raise objection at any time 288. The defendant may raise lack of subject matter jurisdiction at any time during the pendency of the case, even after final judgment has been entered and the case has been appealed on other grounds. Fed. R. Civ. P. 12H3. Indeed, the defendant may even remove the case to federal court, lose there, and then raise lack of subject matter jurisdiction as a ground for invalidating the judgment for the plaintiff. See American Fire and Casualty Co. v. Fin. 341 U.S. 6 1951. Subject matter jurisdiction defects sometimes can even be raised on collateral attack, after all appeals have been exhausted or waived and the judgment has become completely final. 1. Distinguish personal jurisdiction 289. The defendant's failure to raise personal jurisdiction at the earliest time waives objections to personal jurisdiction. See Supra 87. C. Court to raise sua sponte 290. Even if the parties do not raise the issue, the court is to raise subject matter jurisdiction on its own motion. See, e.g., Louisville and Nashville Railroad v. Motley, 211 U.S. 149-1908. Court dismissed appeal for lack of subject matter jurisdiction, even though neither party raised issue. D. Jurisdiction must be resolved before court addresses merits of suit 291. The question of whether a court has jurisdiction must be resolved before the court may decide the merits of the case. Steel Co. v. Citizens for Better Environment, 523 U.S. 83 1998, rejecting doctrine of hypothetical jurisdiction, followed by some appellate court circuits, under which a court would assume it had jurisdiction to decide the case on its merits, where the merits question is more readily resolved than the jurisdiction question, and the party that would prevail on the merits is the same party that would prevail if jurisdiction were denied. 1. Personal jurisdiction challenge may be resolved before subject matter jurisdiction challenge 292. Although a federal court must resolve challenges to its jurisdiction before deciding the merits of a case, there is no jurisdictional hierarchy requiring a federal court to resolve challenges to its subject matter jurisdiction before resolving challenges to its personal jurisdiction. Ruegas Ag v. Marathon Oil Co., 526 U.S. 574 1999. District Court Properly dismissed action removed from state court to federal court for lack of personal jurisdiction, even though there were challenges to the court's removal jurisdiction. 2. Forum non-conveniens dismissal permitted before resolving jurisdiction 293. Even though there are challenges to its jurisdiction, a district court may dismiss on grounds of forum non-conveniens without first resolving those jurisdictional challenges if the defendant meets the heavy burden to justify dismissal on that ground. Sinochem International Co. v. Malaysia International Shipping Corp. 127S, CT. 1 in 184 2007. 4. State Courts 294. This chapter focuses on the subject matter jurisdiction of federal courts. Except for claims within the exclusive jurisdiction of the federal courts infra, 299-302, state court systems usually exercise general jurisdiction, i.e., a state court is available for every type of claim. Within the state court system, however, there may be subject matter jurisdiction limitations that should be kept in mind. A. Specialized Courts 295. In many states, there are specialized courts that deal exclusively with certain types of cases. For example, probate proceedings or matrimonial disputes may have to be raised before a specialized court or a specialized division of the court. B. Monetary Limitations 296. In some states, there are courts that have jurisdiction over claims below a certain dollar amount. These so-called small claims courts have the authority to decide cases involving small sums C, e.g., Cal, Civ, Proc. Code 116-220 less than $5,000, using very informal procedures that may even forbid the participation of lawyers. In addition, there may be more formal courts with jurisdiction limited to claims under a certain amount. C. General Jurisdiction 297. Each state has some court of general jurisdiction. This means that any type of claim can be brought in this court, except those claims within the exclusive jurisdiction of the federal courts. See Infra 299 regarding exclusive jurisdiction. D. Concurrent jurisdiction of federal claims 298. Generally, state courts have jurisdiction concurrent with the federal courts to hear federal claims. If there is concurrent jurisdiction, a plaintiff may choose to file her case in either federal or state court. Indeed, under the Supremacy Clause of the Constitution U.S. Const. Art. Roman 6:2, state courts may not refuse to enforce federal claims unless federal law provides otherwise. Thus, even if for some reason the plaintiff may not file her entire case in federal court, she can still file it in state court. 1. Exception Exclusive Jurisdiction 299. Federal law grants the federal courts exclusive jurisdiction over some types of cases, and state courts therefore cannot adjudicate such claims. Examples of such exclusive jurisdiction include the following. A. Patents, copyrights, and trademarks 300. Federal courts have exclusive jurisdiction when the plaintiff's patent, copyright, or trademark claim arises under a federal statute. 28 U.S.C. 11338 state courts have concurrent jurisdiction, however, to decide claims arising under the common law, e.g., for unfair competition, and to decide claims for breach of contract concerning the license, sale, or other disposition of patents, even if the validity of the patent is challenged. Lear, Inc. v. Adkins, 395 U.S. 653 1969. B. Federal Antitrust Regulations 301. Claims for violation of the federal antitrust laws have been held to be within the exclusive jurisdiction of the federal courts. See Freeman v. B. Machine Co., 319 U.S. 448 1943. States may, however, have parallel state law antitrust provisions within the jurisdiction of the state courts. C. Federal Securities Acts 302. Federal jurisdiction is exclusive in actions brought under the Securities Exchange Act of 1934, including actions under Rule 10b-5 for manipulative or deceptive conduct in connection with a purchase or sale of securities. 15 U.S.C. 78A states may, however, entertain claims for common law fraud arising out of the same events. D. Distinguish Federal Defense 303. When an issue of federal law arises as a defense to a state law claim, the fact that a claim for affirmative relief on the federal ground would be subject to exclusive federal jurisdiction does not prevent the state court from considering the defense. Indeed, under the Supremacy Clause, the state court cannot refuse to entertain the defense. 5. Federal Court's Jurisdiction. A. Limited Jurisdiction 304. Unlike state courts, federal courts are courts of limited jurisdiction. 1. Constitutional Grant 305. Article Roman 3, Section 1 of the United States Constitution establishes the Supreme Court and gives Congress the power to create inferior federal courts. Section 2 of Article Roman 3 sets out the scope of the federal judicial power. It provides that, among others, the federal courts may hear cases arising under the Constitution or federal law, affecting ambassadors, or between citizens of different states. To be constitutional, an exercise of jurisdiction by a federal court must be within the scope of power granted by Article Roman 3, Section 2. 2. Statutory Grant 306. It is not enough that an exercise of federal jurisdiction is merely permissible under the Constitution. There must also be some statutory grant by Congress vesting the federal courts with jurisdiction. Unless Congress has vested a federal court with jurisdiction, the fact that it might do so without violating the Constitution is irrelevant. B. Tactical Considerations 307. Litigants with a choice between state and federal court often prefer federal court for a variety of tactical reasons. 1. Location 308. Federal courts are usually located in metropolitan areas, while many state courts are in less populated areas. 2. Broad Discovery 309. Federal courts may afford broader opportunities for discovery, i.e., pretrial devices to obtain information about a case generally from the other party. Although the breadth of federal discovery has been curtailed, see Infra 18487-18494. 3. Speedy Trial 310. In some locations, state court dockets are backlogged and federal courts are able to offer parties shorter delays to trial. By the same token, where the delay is greater in federal court, a party desiring delay might want to litigate in federal court for that reason. 4. Single Assignment System 311. In most federal courts, cases are assigned to a single judge from the outset. Some litigants believe that this arrangement is more efficient and effective than having the case assigned on a master calendar basis that assigns different aspects to different judges. Most states use the master calendar approach, although some are shifting to a single assignment system. 5. Source of Jurors 312. Federal juries are drawn from the entire federal district, while state court juries are usually drawn from a more limited area, such as a county or part of a county. 6. Manner of selecting judges 313. Federal district judges are nominated by the President and confirmed by the Senate. They may be removed only by impeachment and are relatively insulated from political pressures. Methods of selecting judges vary among states. In a few states, judges are appointed in a similar manner to the federal system. But most state judges are elected, and in many states the elections are either explicitly or for practical purposes partisan. In some states, judges may be regarded as more subject to political or other pressures than federal judges. B. Diversity Jurisdiction. 1. Introduction 314. Most cases brought in federal courts are brought under one of two subject matter jurisdiction statutes, the Diversity Statute 28 U.S.C. 1-332 or the Federal Question Statute 28 U.S.C. 1-331. This section of the summary will discuss diversity jurisdiction. Federal question jurisdiction will be discussed infra. 2. Constitutional Authorization 315. Article Roman 3, Section 2 of the Constitution provides that the judicial power of the United States may extend to controversies between two or more states, between a state and a citizen of another state, between citizens of different states, or between a state or the citizens thereof and foreign states, citizens, or subjects. The usual justification for creating diversity jurisdiction is to afford an alternative forum to out-of-state litigants who might be victims of local prejudice against outsiders. A. What constitutes diversity? 316. The plaintiff and defendant have diverse citizenship if one is a citizen of one state and the other is a citizen of another state or an alien or foreign national. There is no diversity jurisdiction, however, in a suit between two aliens, even if from different countries, e.g., a citizen of India and a Canadian. B. Minimal diversity constitutionally required. 317. The Constitution requires only that one plaintiff be of different citizenship from one defendant, even if there are co-parties who are not of diverse citizenship. State Farm Fire and Casualty Co. v. Tosher, 386 U.S. 523 1967. Absent minimal diversity, the federal courts are forbidden to entertain a case unless it involves a federal question discussed infra. 403 et seq. 3. Diversity Statute 318. The first Congress not only created lower federal courts, but also vested them with diversity jurisdiction by passing the predecessor to 28 U.S.C. Section 1-332. That statute closely tracked the constitutional language. There are two main prerequisites to diversity jurisdiction under the statute: diversity of citizenship and a minimum amount in controversy. A. Diversity of citizenship. 1. Complete diversity requirement. 319. In 18806, the Supreme Court interpreted the diversity statute to require complete diversity, i.e., that there be no defendant having the same citizenship as any plaintiff. Strawbridge v. Curtis, 7 U.S. 267 18006. Although it has made some changes to the statute since then, Congress has not tried to change this interpretation. The Supplemental Jurisdiction Statute granting federal courts jurisdiction to hear supplemental claims related to the claim over which they have original jurisdiction. See infra 455 et seq. Appears to embrace the complete diversity requirement, but could be interpreted to weaken it. See infra 456 et seq. 2. Statutory exceptions to complete diversity. 320. Congress has authorized exercise of federal court diversity jurisdiction in some instances even though there is not complete diversity. A. Interpleader 321. The Federal Interpleader Act permits a federal court to exercise jurisdiction in interpleader actions whenever any two or more adverse parties are of diverse citizenship. 28 U.S.C. 335 A1. The Supreme Court has held that this minimal diversity jurisdiction is constitutional. State Farm Fire and Casualty Co. v. Tosher, Supra. B. Class Action Fairness Act 322. The Class Action Fairness Act of 2005 provides federal district courts with original jurisdiction over certain class actions in which there is minimal diversity between the class members and the named defendants. 28 U.S.C. 1-332 D2. C. Multiparty, Multiforum Jurisdiction 323. The Multiparty, Multiforum Jurisdiction Act confers jurisdiction on the federal district courts for actions arising from accidents that involve the deaths of at least 75 people so long as there is minimal diversity between adverse parties. 28 U.S.C. 369. 3. Alienage Diversity Jurisdiction 324. Section 1E332A2 confers federal subject matter jurisdiction over cases involving a citizen of the United States and a citizen of a foreign country, and Section 1E332A3 confers federal subject matter jurisdiction over cases involving completely diverse citizens of American states in which aliens are additional parties. Example: Jacques, a citizen and resident of France, sues Bob, a citizen of Illinois. Assuming the amount in controversy requirement is met, The case could be in federal court under alienage jurisdiction because it is between a citizen of the United States and a citizen of a foreign country. Example: Mary, a citizen and resident of New York, and Jacques, a citizen and resident of France, sue Bob, a citizen of Illinois. Assuming the amount in controversy requirement is met, the plaintiffs could invoke alienage jurisdiction because the case is between citizens of different states, with an alien as an additional party. Compare Mary, a citizen and resident of New York, and Jacques, a citizen and resident of France, sue Roberto, a citizen and resident of Mexico. The case cannot be in federal court on grounds of diversity because both Jacques and Roberto are aliens. 4. How citizenship determined. A. Natural persons 325. For United States nationals, citizenship, in substance, has the same meaning as domicile. New citizenship may be established by physical presence in the new state and an intention to remain there, i.e., no present intent to go elsewhere. 1. United States national living abroad 326. An American citizen permanently living abroad has no domicile within the United States and is not a citizen of any state. Such a person cannot sue or be sued in federal court on grounds of diversity of citizenship. 2. Citizens of District of Columbia, Puerto Rico, and U.S. Territories 327. Although citizens of the District of Columbia, Puerto Rico, and U.S. Territories might have suffered a similar fate to that of the expatriates, Congress instead provided that they should be treated as citizens of states for purposes of diversity jurisdiction, and the Supreme Court upheld this as constitutional. 28 U.S.C. 1332e, National Mutual Insurance Co. v. Tidewater Transfer Co. 337 U.S. 582-1949. Thus, a citizen of Puerto Rico can sue a citizen of Illinois in federal court under diversity jurisdiction. B. Corporations 328. For diversity purposes, a corporation is deemed to be a citizen of every state in which it is incorporated and of the state in which it has its principal place of business. 28 U.S.C. 10332c. 1. Principal place of business 329. Where the corporation's executive office and its other activities are in the same state, the concept causes no trouble. However, where the executive offices are in one state and its principal production facilities are in another state, the courts may have more trouble determining the principal place of business. Some courts consider the executive office as the nerve center of the corporation and thus the principal place of business, while other courts hold that the main physical plant is the principal place of business. 2. Corporation as alien 330. A corporation organized under the laws of another nation is a citizen or subject of that foreign state for purposes of alienage diversity jurisdiction. See Supra 324. Although it may also be deemed a citizen of an American state if its principal place of business is located in the United States. J.P. Morgan Chase Bank v. Traffic Stream BVI Infrastructure Limited 536 U.S. 88 2002. Even though British Virgin Islands is not recognized as an independent foreign state, a corporation organized under its law is an alien for purposes of diversity jurisdiction. Although the Supreme Court has not ruled on the issue, a foreign corporation that has its principal place of business in the United States would probably be deemed to be a citizen of that state for diversity purposes. See, e.g., Danjak, S.A. v. Pathé Communications Corp. 979 F2D 70 772 9th Sir. 1992. 3. Distinguish Venue 331. For venue purposes, a corporate defendant is usually treated as a resident of every state in which it is subject to personal jurisdiction, not merely its principal place of business. See Supra 149. See Other Artificial Entities 332. For purposes of diversity, unincorporated associations and other non-corporate artificial entities created by state law are viewed as citizens of each state in which any member is a citizen. As a result, complete diversity is often destroyed and diversity jurisdiction is unavailable. 1. Partnerships 333. A business partnership is viewed as an association for diversity purposes. Therefore, the citizenship of each partner must be considered. Cresswell v. Sullivan and Cromwell, 922 F2D 62D Sir. 1990 American law firm partnership could not be sued in federal court on diversity grounds because it included partners who were United States nationals but were domiciled abroad. See Supra 326. A. Limited partnerships 334. In a general partnership, the partners have full individual liability for the partnership's debts. In a limited partnership, the liability of the limited partners is restricted to the amount of their investment, and they have negligible power to control the partnership. Nonetheless, the Supreme Court has held that the citizenships of all limited partners must be taken into account for purposes of determining complete diversity. Carden v. Arcoma Associates, 494 U.S., 185 1990. B. Distinguished Professional Corporation 335. Some enterprises such as law firms that formerly operated as partnerships now operate as professional corporations mainly for tax reasons. Because the shareholder attorneys in such corporations remain individually liable for legal malpractice, arguably their citizenship should be considered for purposes of determining complete diversity. Lower federal courts have held, though, that only the citizenship of the professional corporation should be considered. See, e.g., Catay v. Wadel, 796 F2D 981 7th Sir, 1986. 2. Labor Unions 336. The Supreme Court has held that unions are unincorporated associations for purposes of diversity jurisdiction, and thus the citizenship of all union members is considered. United Steel Workers v. R.H. Bouligny, Inc., 382 U.S., 145 1965. 3. Underwriting Syndicate 337. Lloyd's of London, the underwriting syndicate, has been held to have the citizenship, for purposes of diversity, of every name, i.e., investor. Indiana Gas Co. v. Home Insurance Co., 141 F3D 314 7th Sir, Cert. Denied, 525 U.S., 931 1998. But see certain interested underwriters at Lloyd's of London v. Lane, 26 F3D 39 6th Sir, 1994 as real party in interest. Only Lloyd's itself need be considered in determining whether there is diversity. 4. Business Trusts 338. A business trust involves investments by shareholders who entrust their investments to trustees who control the activities of the trust. State law may give the trustees power to sue and be sued as individuals in their capacity as trustees in connection with trust affairs. When state law does so, and the trustees sue or are sued in their own right, their citizenship, and not that of non-party shareholders, is to be considered in determining the existence of diversity in an action involving the trust. Navarro Savings Association v. Lee, 446 U.S., 458 1980. 5. National Banks 339. Under 28 U.S.C. Section 1348, a national bank chartered by the Comptroller of the Currency of the United States Treasury, rather than by a state, is deemed a citizen of the state in which its main office is located. Wachovia Bank v. Schmidt, 546 U.S., 303-26. 6. Class Action Fairness Act Cases 340. In cases governed by the Class Action Fairness Act, an unincorporated association is deemed to be a citizen of the state in which it has its principal place of business and of the state under whose laws it is organized. 28 U.S.C. 1332 D10. D. Permanent Resident Aliens 341. Aliens admitted to the United States for permanent residence are deemed citizens of the states in which they are domiciled for purposes of determining diversity. 28 U.S.C. 11332A. 1. Caution Possible Constitutional Challenge 342. Although the Constitution requires only minimal diversity, see Supra 317, minimal diversity does not exist between two aliens. Therefore, Section 1E332A might authorize jurisdiction beyond the constitutional grant of federal judicial power. Example: in a suit by a citizen of India, domiciled in Virginia, against a German manufacturer and its American distributor, which was a citizen of Delaware, the court upheld jurisdiction because there was citizen vs. alien diversity, given the presence of the Delaware citizen, but noted possible constitutional problems had that defendant not been sued. Singh v. Daimler-Benz AG, 9F3D 303 3D Sir, 1993. Compare statute held not to authorize. Another court held that Section 1E32A was intended to narrow federal court jurisdiction, and that it therefore should not be interpreted to authorize a suit between aliens even if one were domiciled in an American state. In part, the court so interpreted the statute to avoid constitutional difficulties. Sadeh v. Faruqi, 107 F3D 52 DC, Sir, 1997, and C. Intech USA, LLC v. Engel, 467 F3D 1938 7th Sir, 26. Under Section 1E332A, an alien admitted for permanent residence has dual citizenship for purposes of diversity, and is both a citizen of the state of domicile and an alien. 2. Distinguish aliens generally 343. Otherwise, the only persons who can become citizens of a state are United States nationals. Thus, an alien in this country for an extended stay would still be an alien for purposes of diversity jurisdiction. E. Class Actions 344. In a class action, i.e., an action brought by representatives on behalf of a class consisting of a large number of persons, only the citizenship of the named representatives is considered in determining diversity. Supreme Tribe of Ben Hervey, Kabul, 244 U.S. 356 1921. 1. Class Action Fairness Act Cases 345. The Class Action Fairness Act provides district courts with original jurisdiction over certain class actions in which there is minimal diversity between any class member and any named defendant, so long as other prerequisites are also met. 28 U.S.C. 332 D2. F. Executors, guardians, and trustees 346. The legal representative of an estate or of an infant or incompetent is deemed to have the citizenship of the decedent, infant, or incompetent. 28 U.S.C. 332 C2. G. Fictitious defendants 347. When the plaintiff in a civil case is unable to ascertain the name of a potential defendant, some states allow the plaintiff to sue the unknown defendant under a fictitious name, e.g., John Doe. A number of federal courts have held that such cases could not be heard under diversity jurisdiction because of the uncertainty of the citizenship of the unnamed defendant. See, e.g., Hoffman v. Globe Indemnity Co., 759 F2D 1E 458 9th Cert., 1985 and 1988, a federal statute 28 U.S.C. 14441, see Infra. 497 providing for removal of cases from state court to federal court was amended. The amendment provides that for purposes of removal, the citizenship of defendants sued under fictitious names is to be disregarded. The Diversity Jurisdiction Statute 28 U.S.C. 1E332 was not similarly amended. Nevertheless, it has been held that inclusion of a fictitious defendant neither destroys diversity jurisdiction nor requires that the fictitious defendant be named or dropped from the case. See, e.g., Fat T, Inc. v. Aloha Tower Asak. Piers 7, 8, and 9, 172 FRD. 411D. Haw. 1996. But see Howell v. Tribune Entertainment Co. 106 F3D 215 7th Sir. 1997. Fictitious defendants are not permitted in federal diversity suits. The Supreme Court has not yet resolved the issue. 5. Time for determination 348. Diversity need only exist at the commencement of the action. A. Change before filing 349. It is immaterial that the parties had the same citizenship when the claim arose, and a party may even move to another state to create diversity, as long as there is a genuine change of citizenship. B. Change after filing 350. Similarly, a change in either party's citizenship after the filing of the suit does not deprive the court of jurisdiction, nor will it cure a lack of diversity that existed when the suit was filed. Grupo Dataflux v. Atlas Global Group, LP, 541 U.S. 567 2004 post-filing withdrawal of Mexican partners from Texas Partnership did not cure lack of diversity that existed when suit against Mexican corporation was filed. C. Substituted Party 351. Sometimes after a case is filed, a plaintiff will transfer his interest in the case and the transferee will be substituted for the plaintiff. The general rule is still followed because diversity is assessed at the time the action is filed. Diversity is not destroyed even if the substituted plaintiff is a citizen of the same state as one of the defendants. Freeport-McMoran, Inc. v. KN Energy, Inc. 498 U.S. 426 1991. D. Partial Exception Removal 352. Where an action is removed to federal court from state court on grounds of diversity. Diversity must exist at the time of filing of the suit and on the date of filing of the notice of removal. 6. Realigning Parties 353. In determining diversity, the court will look to the real interests of the parties and may realign them as plaintiffs or defendants according to their real interests. In general, the court will look to the ultimate interests of the parties in realigning them. A. Shareholders' Derivative Actions 354. In a shareholder derivative action in which a shareholder brings a suit to enforce a right of the corporation because the officers of the corporation refuse to bring the suit directly, the corporation, even though nominally joined as a plaintiff, is likely to be realigned as a defendant for diversity purposes if, as is usually the case, it is controlled by persons antagonistic to the shareholder plaintiff. Smith v. Sperling, 354 U.S. 91 1957. 7. Efforts to create diversity 355. 28 U.S.C. Section 1E 359 provides that there shall be no jurisdiction when a person has collusively or improperly been made a party or joined in order to invoke federal jurisdiction. A. Assignment of Claim 356. When a claim is assigned to establish diversity or assigned without significant consideration, the assignment will not create diversity if diversity would not exist had the action been brought in the name of the assignor. Kramer v. Caribbean Mills, Inc., 394 U.S. 823 1969. However, if substantial consideration is given for the assignment, jurisdiction exists even though there would be no diversity between the assignor and the defendant. B. Appointment of Executor 357. Appointment of an out-of-state executor will not create diversity because the executor is deemed to be a citizen of the decedent state. See Supra 346. C. Distinguished Change of Citizenship 358. A genuine change of citizenship can create diversity. See Supra 349. 8. Efforts to defeat diversity 359. There is no similar statute forbidding efforts to defeat diversity, and plaintiffs have some latitude in doing so. A. Joinder of non-diverse defendants 360. Under federal practice, a plaintiff can bring a single action against a number of defendants, as long as the claims against the defendants arise out of the same series of occurrences or transactions and there is a question of law or fact common to all the parties. See Infra 175, 179. Often the plaintiff may add claims against non-diverse defendants and thereby defeat diversity. 1. Limitation Valid Claims 361. The plaintiff must have a valid claim against the non-diverse defendant, or the presence of this defendant will be disregarded in making the diversity determination. 2. Limitation Alternative Grounds for Federal Jurisdiction 362. Removal may be possible if non-diverse defendants are sued if federal jurisdiction can be justified on some other basis, such as federal question jurisdiction, i.e., a case arising under federal law. See Infra 407. 3. Limitation Class Action Fairness Act Cases 363. In cases governed by the Class Action Fairness Act, joining a non-diverse defendant does not preclude federal subject matter jurisdiction because the statute requires only minimal diversity. 28 U.S.C. 1-332 D2. B. Appointment of non-diverse representative 364. The appointment of a non-diverse executor or administrator cannot defeat diversity because the citizenship of such persons is deemed to be the same as that of the decedent. See Supra 346. 9. Effect of lack of diversity. A. Dismissal of non-diverse party 365. The plaintiff often can solve the lack of diversity problem by dismissing the non-diverse party. Newman Green, Inc. v. Alfonso Laraine, 490 U.S., 826, 1989. B. Necessary party 366. Where the non-diverse party is a necessary party, i.e., a party needed for just adjudication, see Infra 1086, the plaintiff may be unable to proceed in federal court. See Infra 190 discussing decision whether to proceed with action in absence of necessary party. B. Jurisdictional amount 367. From the outset, the diversity statute limited federal jurisdiction to cases in which more than a certain minimum amount was in controversy. Currently, diversity jurisdiction is limited to cases involving more than $75,000. Rationale: the monetary limitation seeks to ensure that only substantial cases will be brought in federal court. 1. Time for computing 368. The amount is computed as of the date of commencement of the action. Subsequent events, e.g., part payment, do not defeat jurisdiction. 2. Legal certainty test 369. The jurisdictional amount requirement is satisfied unless the plaintiff's complaint shows to a legal certainty that she could not recover more than the minimum amount. Same. Paul Mercury Indemnity Co. v. Red Cab Co. 303 U.S. 283, 1938. A. No need to itemize damages in complaint 370. The plaintiff ordinarily need not indicate in the complaint how she arrived at the amount of damages claimed. 1. But note disclosure. Early in most cases, the federal rules require that certain disclosures be made, including a computation of any damages claimed. See Infra 1-358. B. Good faith limitation 371. The claim for damages set forth in the complaint is determinative of the amount in controversy if the claim was made in good faith. There need only be some legal possibility of recovering the minimum amount. 1. Removed cases 372. Determination of the amount in controversy may be less strict in actions removed from state court to federal court under the removal statute, since the plaintiff would presumably have no incentive to inflate her claim to satisfy federal jurisdictional requirements when filing in state court. C. Effective judgment for lesser amount 373. The fact that the actual recovery does not exceed the jurisdictional amount does not affect the jurisdiction of the court, as long as the claim was made in good faith. The court may, however, deny the plaintiff costs of suit or impose them on the plaintiff. 28 U.S.C. 1-332b. In practice, this power is rarely used. D. Valuing claims for non-monetary relief 374. Where the remedy sought is not money, e.g., where the plaintiff seeks an injunction ordering the defendant to refrain from doing some act, the courts are split on whether the relief should be valued from the plaintiff's prospective value to the plaintiff or the defendant's prospective cost to the defendant in cases in which the values would differ. Example: plaintiff's perspective. Plaintiff sued to restrain defendant from erecting poles and wires in a way that would injure plaintiff's poles and wires. Although the cost to defendant of changing its operation would be less than the jurisdictional amount, The Supreme Court upheld jurisdiction because the value to plaintiff would exceed that amount. Glenwood Light and Water Co. v. Mutual Light, Heat and Power Co. 239 U.S. 121 1915. Example defendant's perspective. Plaintiffs sued a railroad to quiet title to water rights that were worth far less than the jurisdictional amount to plaintiffs, but a good deal more to defendant, and the court upheld jurisdiction. Ronzio v. Denver and Rio Grande Railroad, 116 F2D 604 10th Sir, 1940. E. Valuing claims for declaratory relief 375. In declaratory relief actions where the plaintiff seeks a determination that he is not liable to the defendant, the amount in controversy is the amount of the claim that would be asserted by the declaratory relief defendant against the declaratory relief plaintiff. With other sorts of declaratory claims, e.g., that plaintiff may continue a course of conduct defendant claims is illegal, the analysis should resemble that for non-monetary relief. F. Interest and costs 376. Interest and costs are excluded. However, attorneys' fees that are recoverable by contract or by statute are considered part of the matter in controversy, rather than as costs, and are included. 3. Aggregation of claims to satisfy requirement 377. Whether separate claims for less than the jurisdictional amount can be aggregated to satisfy the jurisdictional requirement depends on a number of factors. A. Claims of single plaintiff against single defendant 378. All claims of the plaintiff against the defendant, whether or not related, can be aggregated to meet the minimum. Example: plaintiff sues defendant for $50,000 in damages arising from a car accident and for $30,000 arising from an unrelated breach of contract. These amounts may be aggregated to reach the jurisdictional amount. B. Claims of single plaintiff against several defendants 379. Only claims for which all defendants are jointly liable to the plaintiff may be combined. Joint liability is defined narrowly for this purpose. Claims arising from closely related conduct do not satisfy the test. Joint liability would arise in a few situations, such as where the defendants are co-owners of property. It would not arise where the defendants are joint tortfeasors. 1. Note: when the plaintiff alleges that the defendants inflicted separate harms on her as part of a conspiracy, allegations of conspiracy may make defendants jointly liable and therefore permit aggregation of amounts. C. Claims of several plaintiffs against single defendant 380. The claims of multiple plaintiffs can be aggregated only if they have a common undivided ownership interest in the claims. Example: Peter and Penelope are tenants in common in a parcel of land, i.e., each owns an undivided 50% interest. They sue Damon for trespass, alleging $120,000 in total damages to the property. Each plaintiff has suffered only $60,000 damage to his or her own interest, but the plaintiff's undivided interest in the property has been injured. Under these circumstances, Peter and Penelope may aggregate their claims to meet the $75,000 requirement. D. Counterclaims 381. In general, the amount sought on a counterclaim cannot be aggregated with a plaintiff's small claim to satisfy the jurisdictional minimum. But note, a 1961 Supreme Court case, Horton v. Liberty Mutual Insurance Co., 367 U.S. 348 1961 appears to look to the counterclaim as the basis for jurisdiction in a case involving Texas workers' compensation. However, it is regarded by many as limited to its quite unusual facts. 1. Distinguished jurisdiction over counterclaim where plaintiff has satisfied minimum 382. When the defendant's counterclaim arises out of the same transaction and is therefore compulsory c. infra 923, it need not satisfy the jurisdictional minimum requirement because it is clearly within the supplemental jurisdiction of the court c. infra 457-460. With a permissive counterclaim c. infra 922. However, there must be an independent jurisdictional basis and the jurisdictional minimum requirement must therefore be satisfied. 2. Distinguish compulsory counterclaim, sometimes considered when defendant does not move to dismiss 383. A few lower federal courts will allow the amount of defendant's compulsory counterclaim to be used to establish jurisdiction if I. The case was originally filed in federal court. Roman II. The amount of the counterclaim satisfies the jurisdictional minimum of $75,000. And Roman III. The defendant does not move to dismiss for lack of subject matter jurisdiction. See, e.g., Spectator Management Group v. Brown, 131 FRD 123D Cert. 1997, Cert. Denied, 523 U.S. 1998, but this approach does not justify using a counterclaim to satisfy the jurisdictional amount for removal because that would permit the defendant to override the plaintiff's choice to sue in state court. See, e.g., Kaplan v. Computer Sciences Corp. 148F. Sup. 2D 318 SDNY. 21 emphasizing narrow construction required for removal jurisdiction. E. Class Action Fairness Act Cases 384. In cases governed by the Class Action Fairness Act, the claims of class members are aggregated, and federal court jurisdiction exists if the amount sought for the class as a whole exceeds $5 million, even if the claims of no individual class member exceed $75,000. 28 U.S.C. 11332d6. C. Exceptions to exercise of diversity jurisdiction 385. Although the diversity statute does not limit the subject matter of cases brought in federal court, the courts decline to exercise jurisdiction in some types of cases. 1. Domestic Relations 386. As a matter of long-standing statutory construction, there is an exception to diversity jurisdiction that prohibits issuance by a federal court of divorce, alimony, or child custody decrees. However, the exception does not permit a federal district court to refuse to exercise diversity jurisdiction over a tort action for damages, even when the claims are brought by one divorced parent on behalf of children allegedly abused by the other parent. Ankenbrandt v. Richards, 504 U.S. 689 1992. 2. Probate Proceedings 387. Federal courts will not take jurisdiction over the probate or annulment of a will or the administration of a decedent's estate. They will also refrain from endeavoring to dispose of property that is in the custody of a state probate court. However, a federal court must exercise otherwise proper jurisdiction even though the issues may also be involved in litigation before a state probate court. Marshall v. Marshall, 547 U.S. 293-96 Federal Bankruptcy Court had jurisdiction over a claim for damages for tortious interference with the testator's alleged intent to create a trust providing benefits to plaintiff Anna Nicole Smith, even though a state probate court had asserted that it had exclusive jurisdiction over the claim. 3. Local Actions 388. Some federal courts treat the rule that actions regarding title to real property should be litigated at the location of the property supra. 175 as limiting the subject matter jurisdiction of courts to entertain such actions elsewhere. See, e.g., Hayes v. Gulf Oil Corp. 821 F2D 285 5th Sir. 1987, federal and state courts lack jurisdiction over the subject matter of claims to land located outside the state in which the court sits. D. Proposals to repeal Diversity Statute 389. For several decades, there have been calls for the repeal of the diversity statute. Proponents of this move argue that any residue of prejudice against outsiders is insufficient to justify imposing the burden of deciding diversity cases on the federal courts. Those who favor retaining diversity jurisdiction urge that prejudice does persist, and that it is important to preserve options for litigants. It is impossible to forecast the future of this debate. 1. Complex Litigation 390. Whatever the future of diversity jurisdiction generally, there is also sentiment favoring expanding it to cope with the demands of repeated litigation of related matters. 2. Increase in jurisdictional minimum 391. As a partial compromise in the ongoing debate over the continued existence of diversity jurisdiction, Congress raised the jurisdictional amount from $10,000 to $50,000 in 1988 and then to $75,000 in 1996, thus cutting down the number of cases that come within diversity jurisdiction. E. Class Action Fairness Act of 2005 392. Congress found that class actions brought in state court and based solely on state law nonetheless often involved issues of national importance, and also that the class action form itself was often abused in state court, e.g., by shopping for a plaintiff-friendly state court forum. To have issues of national importance heard in federal court, and to curb the alleged abuse of the class action form in state courts, Congress adopted the Class Action Fairness Act of 2005. The act expanded the federal court's original jurisdiction over certain class actions based on state law and included some safeguards for settlements discussed infra 1T25 et seq. For a federal court to have original jurisdiction over a class action under the act, the following requirements must be met. 1. Minimal diversity 393. Under the act, district courts have original jurisdiction over certain class actions in which there is minimal diversity between the class members and the named defendants. 28 U.S.C. 1332d2 specifically, there is minimal diversity under the act if any member of a plaintiff class is a citizen of a state different from any defendant. II. Any member of a plaintiff class is a citizen of a foreign country and any defendant is a citizen of a U.S. state. Or III. Any member of a plaintiff class is a citizen of a U.S. state and any defendant is a citizen of a foreign country. 2. Aggregate claims of $5,394,000. Under the Act, the claims of all class members are aggregated, and the amount in controversy requirement is satisfied if the aggregate claims exceed $5 million. 28 U.S.C. 1332d6. 3. Minimum class size 395. There must be at least 100 members in the proposed class or classes. 28 U.S.C. 1332d5b. 4. Excluded actions 396. Certain class actions are specifically excluded under the Act. A. Primary defendants are states or governmental entities 397. There is no federal court jurisdiction under the Act if the primary defendants are states, state officials, or other governmental entities against whom the court may be foreclosed from ordering relief. See Federal Court Summary. 28 U.S.C. 1332d5a. B. Claims based on securities laws or corporate governance 398. There is no federal court jurisdiction under the Act over a class action that solely involves a claim under federal securities laws or that relates to the internal affairs of a corporation and is based on the laws of the state of incorporation. 28 U.S.C. 1332d9. 5. Decline of jurisdiction 399. In some instances, the district court will decline jurisdiction over a class action, even though the case falls within the jurisdiction provided for by the Class Action Fairness Act. A. Mandatory decline 400. A district court must decline jurisdiction provided by the Act if more than two-thirds of the members of the proposed plaintiff class are citizens of the state in which the action was filed. II. A defendant from whom significant relief is sought is a citizen of that state. And III. The principal injuries were incurred in the state in which the action was filed. 28 U.S.C. 1332d4. B. Discretionary decline 401. A district court may decline jurisdiction provided by the Act if more than one-third, but less than two-thirds of the proposed plaintiff class are citizens of the state in which the action was filed and the primary defendants are also citizens of that state. In that case, the court considers a variety of factors, including whether the claims involve matters of national interest, whether the claims will be governed by the law of the state in which it was filed, and whether the state has a distinct nexus with the class members, the alleged harm, or the defendants. 28 U.S.C. Winning 332 D3. 6. Provisions for Protection of Class Members 402. The Class Action Fairness Act also included provisions designed to protect the interests of class members in connection with proposed settlements. See Infra. 1-297 300. C. Federal Question Jurisdiction. 1. Constitutional Grant. A. Constitutional Provisions 403. Article Roman 3, Section 2 of the Constitution provides that federal judicial power shall extend to 1. Cases in law and equity arising under the Constitution, the laws of the United States, and treaties. This is the major area of federal question jurisdiction. 2. Cases affecting ambassadors, consuls, etc. 3. Cases involving admiralty and maritime jurisdiction, and 4. Cases to which the United States is a party. B. Broad View of Federal Question Power 404. In 1824, the Supreme Court upheld a statute that it read to grant federal courts jurisdiction over any case to which the Bank of the United States, a private bank created by Congress, was a party. It found this acceptable because, even if the suit were about a state law debt, the bank was a federal creation, and in every case there would be a question about whether it could legally sue a federal question. The fact that this question would not be important after it was resolved did not bother the court. The question forms an original ingredient in every cause. Whether it be in fact relied on or not in the defense, it is still a part of the cause, and may be relied upon to uphold federal question jurisdiction. Osborne v. Bank of the United States, 22 U.S. 738 18824. 1. Criticism. Some have criticized this broad view of federal question power as including too many cases in which the background federal question would not really be a viable issue in the case at all. Nevertheless, the Osborne holding stands and permits Congress to define federal question jurisdiction extremely broadly. However, the courts have concluded that Congress has not defined federal question jurisdiction this broadly under the General Federal Question Statute, 28 U.S.C. 1-331. 2. Special Federal Question Statutes 405. The Supreme Court has, however, found such broad definition in some special federal question jurisdiction statutes, such as the Foreign Sovereign Immunities Act, 28 U.S.C. Section 1-330 Verlinden B.V. v. Central Bank of Nigeria, 461. U.S. 480 1983 Congressional Regulation of Foreign Sovereigns Immunity permits federal jurisdiction over aliens' suit against foreign government entity even without any federal cause of action, and the federal statute chartering the American National Red Cross, 36 U.S.C. Section 2 American National Red Cross v. S.G. 505 U.S. 247 1992 chartering statutes language confers original jurisdiction over suits involving the Red Cross, a private but federally chartered corporation, even in cases involving state law claims. C. Claim based on Federal Substantive Law 406. It may be that except where a federal creation such as the Bank of the United States is involved, Congress can assign to the federal courts jurisdiction over claims it creates only by promulgating or providing for a body of federal substantive law to govern the claims or delegating authority to create such substantive law to the courts. Example: Labor Management Relations Act. In the Labor Management Relations Act, Congress granted the federal courts jurisdiction over suits to enforce collective bargaining agreements between employers and unions. The court found this grant of jurisdiction valid despite lack of diversity, stressing the need for national uniformity in enforcement of such agreements and concluding that the legislation does more than confer jurisdiction in the federal courts because the substantive law to apply in suits under the Act is federal law, which the courts must fashion from the policy of our national labor laws. Textile Workers Union v. Lincoln Mills, 353 U.S. 448 1957. 2. Federal Question Statute. A. Introduction 407. Initially, the lower federal courts lacked the general jurisdiction to hear cases based on federal law, i.e., general federal question jurisdiction, until Congress passed the predecessor to 28 U.S.C. Section 1E331. The statute used language very similar to that in the Constitution, granting the federal courts jurisdiction to hear all civil actions arising under the Constitution, laws, or treaties of the United States. 1. Statute interpreted more narrowly than Constitution 408. Despite the similarity between the language of the statute and the Constitution, the Supreme Court has interpreted the statute more narrowly. The remainder of this section, therefore, examines the ways in which the court has limited the reach of the statute. 2. State court jurisdiction over cases raising federal questions 409. As to most federal question issues, jurisdiction in such cases is now concurrent between the state and federal courts. See Supra 298-303. 3. Supreme Court Review 410. Often, when the lower federal courts do not have jurisdiction under the federal question statute, the Supreme Court has jurisdiction to review decisions of state courts involving federal law issues. See 28 U.S.C. Wedding 257. B. Standards for determining whether a federal question is raised 411. The Supreme Court's decisions under the federal question statute are sometimes difficult to reconcile, but look to two basic possibilities. 1. Federal law creates claim 412. If federal law creates the claim sued upon, there generally is no problem in finding that the federal courts have subject matter jurisdiction. As Justice Holmes put it, a suit arises under the law that creates the cause of action. American Well Works Co. v. Lane and Bauer Co. 241 U.S. 257 1916. A. Test under Inclusive 413. The court has since recognized that this description is more useful for describing the vast majority of cases that come within the district court's original jurisdiction than for distinguishing among cases in which jurisdiction is doubtful. Franchise Tax Board v. Construction Laborers Vacation Trust 463 U.S. 1 1983. B. Implied Claims 414. Note that federal claims include claims implied by the courts in addition to private rights of action explicitly created by Congress. See, e.g., J.I. Case Co. v. Borak 377 U.S. 426 1964 implied private right of action for securities fraud in violation of Federal Securities Exchange Act of 1934. However, the Supreme Court has recently taken a cautious attitude toward implying causes of action. For details on implied claims, see Federal Courts Summary. 2. Non-federal claim that turns on construction of federal law 415. If the claim being sued upon is not one created by federal law, but resolution of the suit turns on construction of federal law, application of the federal question statute is more difficult. The Supreme Court has confirmed that federal question jurisdiction can be proper where the vindication of a right under state law necessarily turned on some construction of federal law. Merrill Dow Pharmaceuticals, Inc. v. Thompson, 478 U.S. 804 1986. Example: in a quiet title action in state court, plaintiff sought to regain title to real property that had been seized and sold to defendant by the Internal Revenue Service to satisfy plaintiff's tax delinquency. Plaintiff claimed that defendant's title was invalid because the notice it received of the sale did not satisfy the requirements of the Internal Revenue Code. The court ruled that the quiet title action fell within federal question jurisdiction because the question whether proper notice was given under the Internal Revenue Code involved a matter of substantial federal interest and was an essential element of the state law claim. Grable and Sons Metal Products, Inc. v. Daru Engineering and Manufacturing Co. 545 U.S. 308 2D5. Example: a landowner challenged building restrictions resulting from landmark designation based on state administrative review law. The landowner's challenge to the administrative action was based on federal constitutional objections, and the right to relief under state law therefore required resolution of a substantial question of federal law. City of Chicago v. International College of Surgeons, 522 U.S. 156, 1997. Example: a shareholder sued to enjoin a corporation in which he held stock from purchasing bonds issued by federal land banks. The shareholder asserted that under state law the corporation was forbidden to invest in bonds that were not legally issued. The only issue in the case was whether the bonds were validly issued under federal law, and the Supreme Court held that there was federal question jurisdiction. Smith v. Kansas City Title and Trust Co. 255 U.S. 180, 1921. Compare: a railroad employee sued his employer for injuries sustained on the job, which he alleged were caused by a defective uncoupling lever that did not comply with federal standards for safety equipment. The Supreme Court held that the fact the alleged violation of the federal standard was an element of the state law tort claim did not fundamentally change the state law nature of the action, and that jurisdiction was absent. Moore v. Chesapeake and Ohio Railway, 291 U.S. 205, 1934. A. Absence of implied federal claim 416. In Merrill Dow, Supra, the court held that there was no federal question jurisdiction over a state tort claim for negligent manufacture of a drug, although the claim relied on the defendant's alleged violation of the Federal Food, Drug, and Cosmetic Act, FDCA. The parties agreed that there was no implied federal cause of action, and the court reasoned that in that circumstance it would flout the will of Congress to allow federal jurisdiction over a state law claim turning on a violation of the FDCA. In a later case, however, the court cautioned that Merrill Dow should be read in its entirety as treating the absence of a federal private right of action as evidence relevant to, but not dispositive of, the determination whether there is federal question jurisdiction. Grable and Sons Metal Products, Inc. v. Daru Engineering and Manufacturing Co., Supra. B. Substantial bearing on outcome 417. Where federal law is an element of a state law claim, it suffices to support federal question jurisdiction only where it is important to the outcome of the case. The right or immunity must be such that it will be supported if the Constitution or laws of the United States are given one construction or effect, and defeated if they receive another. Gully v. First National Bank, 299 U.S. 109, 1936. 1. But note constitutional power under Osborne v. Bank of the United States, Supra, 404. The unimportance of the question to the dispute before the court may not matter. C. Nature of federal interest 418. In Merrill Dow, Supra, the court suggested that it would be helpful to focus on the nature of the federal issues at stake, and that this approach could reconcile the results in the Moore and Smith cases, Supra. In Smith, jurisdiction was proper because the validity of an act of Congress was directly drawn into question, and there was a substantial federal interest in this question. On the other hand, in Moore, the federal issue related to the employer's compliance at one place and time with one federal safety standard, and there was little federal interest in this isolated incident. 1. Federal claim not necessary 490. The Supreme Court settled a circuit split over the interpretation of Merrill Dow, deciding that a federal right of action is not necessary for federal question jurisdiction over a state law claim under Merrill Dow. The federal interest may have the nature and importance required by that decision in other ways. Grable and Sons Metal Products, Inc. v. Daru Engineering and Manufacturing Co., Supra. C. Well-pleaded complaint rule 420. Generally, a federal court will not have federal question subject matter jurisdiction unless the federal question appears in the plaintiff's well-pleaded complaint. Federal questions raised by an answer to a complaint are not sufficient. The well-pleaded complaint rule serves as a quick and reliable sorting device for allocating subject matter jurisdiction between the state and federal courts. 1. Federal element of non-federal claim properly included under Pleading Rules 421. Sometimes a plaintiff who has a state law claim will want to sue in federal court but cannot bring a diversity action. Such a plaintiff might try to get the case into federal court by injecting a federal law issue into the complaint, even though it is not required to be included by the rules governing pleading infra 630-670. This does not suffice to support federal question jurisdiction. The federal issue must be an element of the state law claim that is required to be included in the complaint to state a claim under the applicable rules of pleading, for that is what makes these allegations well pleaded. 2. Anticipation of defense insufficient 422. Similarly, a plaintiff who wants to sue in federal court may try to raise a federal question to invoke jurisdiction by including in his complaint allegations relating to a federal law defense that the defendant might raise. Such an allegation in anticipation of a defense is not a sufficient basis for federal question jurisdiction. Under the well-pleaded complaint rule, allegations going to an anticipated defense are not required to be in a complaint. Example: plaintiffs sued defendant railroad in federal court alleging that the railroad had breached a contract to provide plaintiffs with free lifetime passes to ride the railroad. Breach of contract is a state law claim. The railroad had granted plaintiffs the passes to settle plaintiffs' personal injury claims against it. Diversity jurisdiction was not available. In an attempt to invoke federal question jurisdiction, plaintiffs, in their complaint, alleged that defendant would defend the breach of contract action by claiming that a newly enacted federal statute prohibited such lifetime passes. They further alleged that the statute should not apply to them, or that the statute unconstitutionally deprived them of their property without due process of law. The Supreme Court held that the federal courts did not have federal question jurisdiction over the case because the allegations relating to the federal statute were not essential to plaintiff's action for breach of contract. They merely anticipated a defense that the railroad would have to plead and prove. Louisville and Nashville Railroad v. Motley, Supra, 290. 3. Federal counterclaim insufficient 423. Like a federal defense to a state law claim, a counterclaim based on federal law, even if compulsory, does not create a federal question that justifies jurisdiction under Section 1E 331. The defendant should not be able to defeat a plaintiff's right to have a state law claim heard in state court by asserting a counterclaim based on federal law. Holmes Group v. Vornado Air Circulation Systems, Inc., 535 U.S. 826-22. 4. Removed cases 424. As discussed earlier, usually state courts have concurrent jurisdiction to hear federal question cases, and sometimes a plaintiff will choose to file a federal law-based action in state court. As will be discussed later infra 486. In some circumstances, a defendant has a right to remove such cases from the state court to the federal courts. In removal cases, the general rule discussed above applies. A case cannot be removed on the basis of federal question jurisdiction unless the federal question appears on the face of the plaintiff's well-pleaded complaint. The fact that the defendant has raised a federal defense is irrelevant. A. Criticism. One of the reasons for the well-pleaded complaint rule that courts are not to consider federal claims raised in anticipation of a federal defense is that there is no way to be certain what defenses will be raised in a defendant's answer. Thus, there is no way to predict whether a federal question will actually be involved. But this argument loses its bite in removed cases, since removal must be on the defendant's motion, and the defendant can definitively establish whether he will raise a federal defense in his answer. B. Plaintiff's election not to assert federal claim 425. To prevent the defendant from removing the case to federal court, a plaintiff might artfully plead her case to avoid a federal question. Generally, this is permissible on the rationale that the plaintiff is the master of her complaint and cannot be compelled to assert a claim that she chooses not to assert. 1. Partial exception federal displacement of state law 426. The Supremacy Clause of the United States Constitution making federal law the supreme law of the land makes it possible for a state cause of action to be preempted by federal law. Ordinarily, preemption is a defense, and the possibility that federal law preempts a state law claim does not provide a basis for federal question jurisdiction. However, Congress may so completely preempt a particular area that any claim in that area is necessarily federal in character. This is rare. Congress has displaced state law in only a few statutory schemes. See, e.g., Metropolitan Life Insurance Co. v. Taylor, 481 U.S. 58 1987 state law displaced by Employee Retirement Security Act, and C. Avco Corp. v. Machinists, 390 U.S. 557 1968 state law disputes between employers and employees displaced by 301 of Labor Management Relations Act when Congress has so displaced state law in the area. A plaintiff may not through artful pleading elude federal jurisdiction by electing not to plead the federal claim because there is no other claim in the area. The case may be removed on federal question grounds because the only possible claim in the area is federal. Example: a state court usury suit against a national bank could be removed because the National Bank Act, 12 U.S.C. 85 provides the exclusive cause of action for usury against national banks, superseding claims based on state usury laws. Beneficial National Bank v. Anderson, 539 U.S. 1 2003. 2. Distinguished Federal Claim Preclusion 427. If a federal court enters a final judgment on a federal claim under the doctrine of claim preclusion or res judicata c. infra, 2262-2303, any related claim is barred. But this effect does not displace state law in the same manner as Congress has done in the statutory schemes mentioned above, and claim preclusion is an affirmative defense. Hence, if a plaintiff later files a state court suit asserting only a state law claim based on the same events, that would usually be subject to res judicata, but that fact would not be a ground for removal. Rivet v. Regions Bank, 522 U.S. 470 1998. C. Federal counterclaim insufficient 428. As with a counterclaim in federal court, a federal law counterclaim in state court does not create federal subject matter jurisdiction and does not provide a basis for removal. Holmes Group v. Vornado Air Circulation Systems, Inc., Supra. 5. Declaratory Judgment Cases 429. Congress has adopted the Declaratory Judgment Act 28 U.S.C. 2201, which allows parties to seek a declaration of rights rather than a specific remedy. The Supreme Court has held that when actions are filed under the Act, jurisdiction does not depend on whether a federal question appears in the complaint seeking the declaratory judgment. Instead, the federal court should essentially pretend that the action is for a coercive remedy, e.g., an injunction, specific performance, damages, and determine whether a hypothetical, well-pleaded complaint for the coercive remedy would have presented a federal question. Skelly Oil Co. v. Phillips Petroleum Co., 339 U.S. 667 1950. The rationale is that the Declaratory Judgment Act was not intended to expand federal court jurisdiction, and a well-pleaded complaint in a declaratory judgment action might contain a federal question, but that federal question would only be a defense in a coercive action. Example: if in Louisville and Nashville Railroad, Supra, 422, the railroad had sued the Motleys for declaratory relief, its complaint might have alleged that the Motleys claimed a contract right to continue receiving free passes, but that an act of Congress had invalidated such passes. Had this hypothetical suit been filed in federal court, the court should determine whether it had subject matter jurisdiction by asking whether it would have jurisdiction over a breach of contract action brought by the Motleys. As we have already seen, the impact of the federal legislation would only be a defense in such a suit, and it therefore would not provide a basis for jurisdiction over the railroad's hypothetical declaratory relief action. 6. Supreme Court Jurisdiction 430. The well-pleaded complaint rule does not apply to cases appealed from state courts to the United States Supreme Court. Thus, even though a lower federal court does not have subject matter jurisdiction to hear a case because the federal claim arises only as a defense, the Supreme Court may hear an appeal from a state court judgment entered in essentially the same case. 28 U.S.C. 1257, and see Louisville and Nashville Railroad v. Motley, 219 U.S. 467 1911 Court reaches the Motley's federal arguments that federal statute did not apply to them and that if it applied, it unconstitutionally deprived them of property on merits on appeal from state court judgment. Compare Supra 422. D. Plausible assertion of federal right sufficient 431. A federal claim or question is sufficient to vest the court with jurisdiction unless it clearly appears to be immaterial or made solely for the purpose of obtaining jurisdiction, or where the claim is wholly insubstantial and frivolous. The litigant need not show that he will prevail on the merits of the claim. The federal claim need only be arguable. Bell v. Hood, 327 U.S. 678 1946 Rationale. A court is not to delve too deeply into the merits of the federal claim at this point because the court is required to determine whether it has subject matter jurisdiction before it considers the merits. Steele Co. v. Citizens for Better Environment, Supra 291. Example: the plaintiff brought a Title Roman VII claim and related state law claims alleging employment discrimination. Title Roman VII defines an employer as one that has more than 15 employees. After trial, the defendant moved to vacate a judgment in favor of the plaintiff and to dismiss both the Title Roman VII claim and the related state law claims for lack of subject matter jurisdiction based on the contention, raised for the first time after the verdict, that it had fewer than 15 employees, which the defendant argued deprived the court of subject matter jurisdiction. The Supreme Court held that the 15-employee requirement was a substantive element of the claim and not a jurisdictional requirement. Had the defendant raised this issue successfully by an early motion to dismiss for failure to state a claim or for summary judgment, the district court nonetheless might have exercised supplemental jurisdiction over the state law claims. See Infra 477. Arbaugh v. Y&H Corp. 546 U.S. 500 2006. Example: in Merrill Dow, Supra 415, the Supreme Court accepted the parties' concession that the FDCA did not give rise to an implied federal claim and, therefore, provided no basis for exercise of federal question jurisdiction. Yet, when other plaintiffs sued, contending that the FDCA gave rise to implied claims, those were held sufficient to support federal question jurisdiction. Until this court or the Supreme Court holds that there is no implied private right of action under the FDCA, the opposite position cannot be deemed either frivolous or insubstantial. In re Benedictine litigation, 857 F2D 296 Sir. 1988. 1. Effective dismissal on pleadings 432. Once the court has decided that a federal question is present, it has subject matter jurisdiction over the case. If the court later dismisses the case for failure to state a federal claim, the decision is on the merits. There are differences between the effect of a dismissal for lack of subject matter jurisdiction and dismissal for failure to state a claim. A. Res judicata 433. If the court dismisses for failure to state a federal claim, that decision on the merits acts as res judicata. See Infra 287 for discussion of res judicata. A dismissal for lack of subject matter jurisdiction has no res judicata effect. B. Supplemental jurisdiction 434. If a court dismisses for lack of jurisdiction, it cannot hear any part of the case. However, if the court decides it has jurisdiction and then dismisses for failure to state a federal claim, it may exercise supplemental jurisdiction see below over related state law claims and retain the case. But because state law claims should usually be dismissed as a matter of discretion, if the federal claims are dismissed early in the action see Infra 477, this possibility is rarely important. E. No jurisdictional amount 435. Where the court's federal question jurisdiction is properly invoked, there is no minimum amount in controversy requirement except in a few minor categories of cases. D. Supplemental jurisdiction. 1. Introduction. A. Historical basis 436. From an early date, the Supreme Court recognized that federal question jurisdiction could not be limited to a decision of federal issues presented in a case. In 1824, the court confirmed that a lower court exercising federal question jurisdiction could decide all issues in a case, not just the federal questions. Osborne v. Bank of the United States, Supra, 404 rationale. The basis for this reasoning was that the federal courts had jurisdiction over a whole case as expressed by the Constitution. As joinder of claims and parties relaxed, the concept of the scope of the constitutional case expanded to encompass claims based on state law and claims against additional parties. B. Goal 437. The goal of supplemental jurisdiction is to promote judicial economy and consistency of decision by removing obstacles to having all related controversies decided in one proceeding. As the Supreme Court put it, under the federal rules of civil procedure, the impulse is toward entertaining the broadest possible scope of action consistent with fairness to the parties. United Mine Workers v. Gibbs, 383. U.S. 715-1966. C. Effect decision may be based on state law alone 438. Federal courts exercising federal question jurisdiction can rest a decision entirely on issues of state law, without reaching issues of federal law. Where federal constitutional issues are raised, this is often the preferable approach, because it is said that courts should try to avoid unnecessary decision of matters of constitutional law. Seiler v. Louisville and Nashville Railroad, 213 U.S. 175-99. 2. Background of supplemental jurisdiction pendant and ancillary jurisdiction 439. Supplemental jurisdiction, provided by statute in 1990, must be understood against the background of the pre-existing doctrines of pendant and ancillary jurisdiction, which had developed in court decisions over several decades. Note, instructors have different preferences concerning the attention to be devoted to these topics. Your instructor might not emphasize these pre-existing doctrines. In that case, you may find it best to skip from this point to 455, where discussion of the supplemental jurisdiction statute begins. A. Ancillary jurisdiction 440. The doctrine of ancillary jurisdiction originated in cases where the federal court controlled property that was claimed by a litigant who was properly before the court. In such cases, ancillary jurisdiction allowed the court to entertain claims of others to the property even though the court had no independent basis for jurisdiction over those claims. Freeman v. Howe, 65 U.S. 451-860. Thereafter, the doctrine was expanded. Generally, ancillary jurisdiction involved assertion of a claim by a party other than the plaintiff that was related to the claim made by the plaintiff. The operation of ancillary jurisdiction is best understood from an examination of the various contexts in which it arose. 1. Counterclaims 441. When a plaintiff brings a suit against a defendant, the defendant may file a counterclaim against the plaintiff. A counterclaim arising from the same transaction as the plaintiff's claim fell within the ancillary jurisdiction of the court. Note that under Federal Rule 13a, such a counterclaim is compulsory, meaning that it would be barred by res judicata unless asserted. Compare, if a counterclaim did not arise from the same transaction as the plaintiff's claim, a permissive counterclaim under Fed. R. Civ. P. 13b, it was not within the court's ancillary jurisdiction, and there had to be an independent basis for federal jurisdiction. 2. Third-party practice impleader 442. Federal Rule 14 permits the defendant to assert a claim against another person, not originally a party, called a third-party defendant to the action, seeking indemnity in whole or in part for the claim the plaintiff has asserted against the defendant. There was ancillary jurisdiction over the third-party claim. A. Distinguished claim by plaintiff against third-party defendant 443. If the plaintiff asserted a claim against the third-party defendant in a diversity case, however, there had to be an independent basis for federal jurisdiction over that claim. Example: plaintiff sued a power district for causing the death of her husband when a crane hit a high-tension wire. The power district impleaded the operator of the crane and later obtained summary judgment against plaintiff's claim. Plaintiff amended her complaint to assert a claim against the operator of the crane, but there was no diversity between plaintiff and the third-party defendant. The Supreme Court held that there was no jurisdiction over plaintiff's claim against the third-party defendant. Owen Equipment and Erection Co. v. Kroger, 437 U.S. 365 1978 rationale. If ancillary jurisdiction were permitted in such cases, plaintiffs could circumvent the requirement of complete diversity by suing only diverse potential defendants and waiting for them to implead other non-diverse, potentially responsible parties. B. Contrast claim by third-party defendant against plaintiff 444. A number of cases held that there is ancillary jurisdiction over a claim by the third-party defendant against the plaintiff. See, e.g., Revere Copper and Brass, Inc. v. Eatna Casualty and Surety Co., 426 F2D 709 5th Sir, 1970. 1. Compulsory counterclaim by plaintiff 445. If the third-party defendant filed a claim against the plaintiff, and the plaintiff had a counterclaim arising out of the same events from which the defendant's claim arose, the counterclaim would have been within the court's ancillary jurisdiction because it would be compulsory. See Supra, 441. Caution: this may have been changed by the Supplemental Jurisdiction Statute, discussed infra, 471. 3. Cross Claims 446. Federal Rule 13G allows one defendant to assert a cross-claim against another defendant if it arises out of the transaction sued upon by the plaintiff. Because of the relation to the original claim filed by the plaintiff, there was ancillary jurisdiction over the cross-claim. Lassa per L'Industria v. Alexander, 414 F2D 143 6th Sir, 1969. 4. Intervention 447. Federal Rule 24 allows persons who claim an interest in the litigation to intervene and become either plaintiffs or defendants in the suit. When they could intervene of right because the litigation would inevitably affect their rights or because the present parties would otherwise be subjected to the risk of inconsistent judgments, see infra 1E 132 et sec. It was ordinarily held that ancillary jurisdiction covered their participation. A. But note: when intervention was merely permissive, an independent jurisdictional basis was required. 5. Necessary parties 448. Under Federal Rule 19, certain non-parties are considered necessary parties because their rights are implicated in the action or because the present parties run the risk of inconsistent or multiple liabilities if they are not joined. See infra 1A 132 et sec. As to such parties, an independent basis for jurisdiction was required. If there was no independent basis for jurisdiction, the court might have had to dismiss the case. See Fed. R. Civ. P. 19b enumerating factors that affect decision whether to dismiss when necessary party cannot be joined. See infra 1T90. B. Pendent jurisdiction 449. Pendent jurisdiction developed in cases where the plaintiff had both federal and non-federal claims against a non-diverse defendant arising from the same event. The court was said to have jurisdiction over the state law claims, which are appended to the federal claim. Thus, it referred to the assertion of non-federal claims by the plaintiff that are related to the plaintiff's federal claim. Example: plaintiff copyrighted a play, revised it, and submitted both versions to defendant for possible production. When defendant did not produce the play, plaintiff sued, claiming that defendant had stolen parts of both the copyrighted and uncopyrighted versions for use in a play produced by defendant. Plaintiff asserted a federal copyright claim and 2 state law claims of unfair competition, one for use of the copyrighted version and the other for use of the uncopyrighted version. The Supreme Court held that there was pendent jurisdiction over the unfair competition claim relating to the copyrighted version because it results from the same acts which constitute the infringement and is inseparable therefrom. But in a narrow ruling the court later rejected as unnecessarily grudging, it also held that there was no jurisdiction over the unfair competition claim related to the uncopyrighted version because that claim was independent of the claim of copyright infringement. Hernar-Slur, 289 U.S. 238 1933. Example. Plaintiff claimed that defendant union violated federal labor laws and committed the state law tort of interference with contract by pressuring customers of plaintiff not to employ his services. Both federal and state claims arose from the same series of actions by defendant's agents. The federal court could grant plaintiff judgment on the state law claims even if it decided after trial that plaintiff had not established a violation of federal law. United Mine Workers v. Gibbs, Supra, 437. 1. Pendent party jurisdiction 450. If a plaintiff has a claim within original federal jurisdiction against the first defendant and a claim not within original federal jurisdiction arising out of the same event against the second defendant, the plaintiff might seek to append the claim against the second defendant to the claim against the first defendant, noting that the addition of a completely new party would run counter to the well-established principle that federal courts, as opposed to state trial courts of general jurisdiction, are courts of limited jurisdiction. Aldinger v. Howard, 427 U.S. 1976. The Supreme Court took a limited approach to pendent party jurisdiction. A. Diversity Claim 451. The Supreme Court refused to allow a plaintiff to assert a claim against a non-diverse, third-party defendant because allowing this maneuver would enable plaintiffs to circumvent the complete diversity requirement. Owen Equipment and Erection Co. v. Kroger, Supra, 443. B. Federal Question Claim 452. Even where there was exclusive federal jurisdiction over a federal claim against one defendant, the Supreme Court held that there could be no jurisdiction over a related, non-federal claim against a non-diverse party because a grant of jurisdiction over claims involving particular parties does not itself confer jurisdiction over additional claims by or against different parties. Finley v. United States, 490 U.S., 545 1989. 2. Class Actions 453. Pendent jurisdiction over class actions was complicated. While the issue of diversity was determined only by looking to the named class representative C. Supra, 344, the Supreme Court held that where a class action was brought under diversity jurisdiction, each class member had to have a sufficient claim, unless the claims were legally joint. Zahn v. International Paper Co., 414 U.S., 291 1973. A distinguished federal question class action. In a federal question class action, ordinarily there was no jurisdiction problem since the amount in controversy requirement would not apply and each class member would have a claim within the subject matter jurisdiction of the federal court. C. Lack of statutory basis 454. In a 1989 decision regarding pendent party jurisdiction, the Supreme Court stressed that pendent and ancillary jurisdiction appeared to contravene the principle that, as regards all courts of the United States inferior to this tribunal, 2 things are necessary to create jurisdiction, whether original or appellate. The Constitution must have given to the court the capacity to take it, and an act of Congress must have supplied it. To the extent that such action is not taken, the power lies dormant. Finley v. United States, Supra. Although Finley left existing pendent claim precedents undisturbed, it cast doubt on all extensions of ancillary jurisdiction to claims against added parties without express congressional authorization. 3. Supplemental Jurisdiction Statute 455. In 1990, largely to restore the law to its pre-Finley state, Congress enacted the Supplemental Jurisdiction Statute, 28 U.S.C. 1367. A. Jurisdictional power to limit of Constitution 456. The statute grants federal courts that have original jurisdiction over a claim supplemental jurisdiction over all other claims that form part of the same case or controversy under Article Roman III of the Constitution. 28 U.S.C. 10367a. The focus of the constitutional inquiry is whether the claims sought to be added to those within federal jurisdiction are part of one constitutional case. United Mine Workers v. Gibbs, Supra, 449, and C. Supra, 436. 1. Standard for supplemental jurisdiction in federal question cases 457. In United Mine Workers v. Gibbs, Supra, the Supreme Court articulated the following three-part test to determine whether a federal court has the power to entertain pendent claims. A. Substantial federal claim 458. The federal claim must be sufficiently substantial to support federal question jurisdiction. See Supra, 431 et seq. B. Common nucleus of operative fact 459. The federal and non-federal claims must derive from a common nucleus of operative fact. C. 1 Judicial Proceeding 460. The federal and non-federal claims must be such that the plaintiff would ordinarily be expected to try them in one judicial proceeding. 2. Diversity Cases 461. The Supreme Court has suggested that the same test may apply to determine the outer constitutional limits of diversity jurisdiction. Owen Equipment and Erection Co. v. Kroger, Supra, 451. A. Note. Because only minimal diversity is required by the Constitution. See Supra. 317. As long as one defendant is diverse from one plaintiff, there is no constitutional difficulty with exercise of jurisdiction over the whole case, including non-diverse parties. 3. Pendent Party Jurisdiction 462. Section A of the Supplemental Jurisdiction Statute explicitly grants supplemental jurisdiction over claims that involve the joinder or intervention of additional parties. 4. Time of Decision 463. The question of constitutional power will ordinarily be resolved on the pleadings. United Mine Workers v. Gibbs, Supra. 5. Contrast to original jurisdiction statutes 464. Unlike the statutes granting federal question and diversity jurisdiction, which have been interpreted not to go to the constitutional limit. See Supra. 319. 408. Subsection A of the Supplemental Jurisdiction Statute does go to the maximum extent allowed by the Constitution. 6. Mandatory Exercise 465. It has been held that federal courts should exercise supplementary jurisdiction granted by 28 U.S.C. Section 1D 367a unless a ground for declining jurisdiction exists under 28 U.S.C. Section 1D 367cc infra 474-478. Executive Software North America, Inc. v. District Court, 24 F3D 18545 9th Sir. 1994. B. Exception for Diversity Cases 466. When federal subject matter jurisdiction is founded solely on diversity of citizenship, supplemental jurisdiction is limited. 28 U.S.C. 1E367b. The legislative history indicates that this was done to implement the rationale of Owen Equipment, Supra. This represents Congress's explicit adoption of the complete diversity requirement long ago adopted by the Supreme Court. See Supra. 319. 1. Claims by plaintiffs 467. In diversity-only cases, there is no supplemental jurisdiction over claims by plaintiffs against persons made parties under Rule 14 Impleader, Rule 19 Necessary Party Joinder, Rule 20 Permissive Party Joinder, or Rule 24 Intervention. 2. Claims by parties joined as plaintiffs under Rule 19 or 24 468. There is no supplemental jurisdiction over claims by persons proposed to be joined pursuant to Rule 19 or 24. Note: this affects a change. Formerly, there was thought to be jurisdiction over claims by plaintiff intervenors of right C supra 447. A. Distinguish Rule 20 Joinder of Plaintiffs 469. The Supplemental Jurisdiction Statute has no provision excluding claims by plaintiffs joined permissively pursuant to Rule 20. The Supreme Court has settled that claims by completely diverse plaintiffs in a diversity case, when one plaintiff has a claim satisfying the amount requirement, but others with related claims do not, come within supplemental jurisdiction. The Court's opinion, however, indicated that incomplete diversity would still destroy jurisdiction as to all claims. Exxon Mobil Corp. v. Alapata Services, Inc., 545 U.S. 546 5 upholding supplemental jurisdiction. In suit by injured child who claimed more than $75,000 over related claims of family members who were diverse from defendant but did not satisfy amount requirement. B. Distinguish Class Actions 470. The legislative history of the Supplemental Jurisdiction Statute states that the statute was not intended to affect the requirement in most state law class actions that each class member had to satisfy the amount in controversy requirement. See Supra 453. However, since Section 1E 367b does not expressly limit the use of supplemental jurisdiction in diversity class actions, the Supreme Court has held that related claims of class members may be appended to the jurisdictionally sufficient claims of plaintiff class representatives, even though the class members' claims could not themselves satisfy the amount in controversy requirement. Exxon Mobil Corp. v. Alapata Services, Inc., Supra. Furthermore, under the rule of Supreme Tribe of Ben-Hur v. Kabul, Supra. 344, which was not affected by Section 1E 367, only named class representatives need be of diverse citizenship from the class's opponents. Thus, supplemental jurisdiction can extend to below amount claims of diverse and non-diverse unnamed class members alike. C. Distinguish compulsory counterclaims by plaintiffs 471. Under prior case law C Supra 445, there could be ancillary jurisdiction over a compulsory counterclaim by a plaintiff against a non-diverse third-party defendant in a diversity case. Evra Corp. v. Swiss Bank Corp. 673 F3D 951 7th Sir. Cert. Denied. 459 U.S. 1-17-1982. It is unclear whether this rule survives the Supplemental Jurisdiction Statute's prohibition of jurisdiction over claims by plaintiffs against such parties. The legislative history's expression of intent to preserve most prior case law, and Section 1E 367b's concluding language, making its restrictions applicable only when exercising jurisdiction, would be inconsistent with the jurisdictional requirements of Section 1E 332, suggests that this form of supplemental jurisdiction might survive. But see Guaranteed Systems, Inc. v. American National Can Co. 842 Sup. 855 MDNC. 1994, although Owen Equipment and Erection Co. v. Kroger, Supra. 461, alone would not have forbidden ancillary jurisdiction over diversity plaintiffs' compulsory counterclaim against non-diverse third-party defendant. Section 1E 367b bars supplemental jurisdiction. D. Distinguish claims against defendants joined under Rule 2472. Although Section 1E 367b does not forbid jurisdiction over claims by plaintiffs joined under Rule 20, as the Supreme Court noted in Exxon Mobil, Supra, Section 1E 367b explicitly excludes supplemental jurisdiction over claims against defendants joined under Rule 20. 1. Note: if separate suits are filed against each defendant, plaintiffs can solve this problem and may seek to consolidate these separate suits for combined treatment. CFED R. Civ. P. 42A. C. Discretionary Decline of Jurisdiction 473. The statute explicitly authorizes district courts to decline jurisdiction in certain circumstances that largely implement discretionary factors identified in United Mine Workers v. Gibbs, Supra, 457-460, 28 U.S.C. 1367C. 1. Grounds to decline 474. A federal court may decline to exercise supplemental jurisdiction, but only on the basis of one of the following four grounds. Executive Software North America, Inc., v. District Court, Supra, 465. A. Novel or complex issue of State Law 475. If the law to be applied to the non-federal claim is uncertain, the district court may decline to entertain that claim so that the parties can get a surer-footed reading of applicable law from a state court. 1-367C1. United Mine Workers v. Gibbs, Supra. B. Non-federal claim substantially predominates 476. The federal court may conclude that the non-federal claim is the real body of the case. 28 U.S.C. 1-367C2. The court should not tolerate a litigant's effort to impose upon it what is in effect only a state law case. United Mine Workers v. Gibbs, Supra. E. All original jurisdiction claims dismissed 477. If all claims over which the federal court had original jurisdiction are dismissed, the court may dismiss the non-federal claims. 28 U.S.C. 1-367C3. In deciding whether to do so, the court should consider the amount of time invested in the case by the court. D. Extraordinary circumstances 478. The federal court may also decline to exercise supplementary jurisdiction in extraordinary circumstances if there are other compelling reasons for declining jurisdiction. 28 U.S.C. 1-367C4. 1. Complication of Case 479. In United Mine Workers, the Supreme Court said that complication of the case in federal court would justify refusal to entertain the non-federal claims. It has been held that this ground for decline of jurisdiction was limited by the statute to instances in which the district court finds that exceptional circumstances exist in the case and that these provide compelling reasons for decline of jurisdiction. Executive Software North America, Inc., v. District Court, Supra. 2. Distinguish state law tied to questions of federal policy 480. When the state law claim is closely tied to a question of federal policy, this link argues in favor of exercise of supplemental jurisdiction. Example: when the allowable scope of the state law claim implicates the federal doctrine of preemption, it is desirable for the federal court to employ supplemental jurisdiction. United Mine Workers v. Gibbs, Supra. Compare preemption defense. Preemption is usually an affirmative defense and therefore not a ground for exercise of original federal question jurisdiction under the well-pleaded complaint rule. See Supra 426. 3. Timing of decision 481. The question whether to decline to exercise supplemental jurisdiction remains open throughout the case. However, the longer the court waits, the more effort it puts into the case, and the effort invested by the court may be a reason to retain jurisdiction. Nevertheless, the court may decide, even after trial, not to entertain non-federal claims. D. Tolling of limitations 482. The limitations period for any claim asserted under supplemental jurisdiction or any other claim in the same action voluntarily dismissed at the same time or later is tolled while the claim is pending in federal court and for 30 days after the federal court dismisses it. 28 U.S.C. 1-367D. The rationale for the tolling is that a plaintiff should not be subjected to the risk that her claim will be barred by limitations if the federal court declines to exercise supplemental jurisdiction, or if the plaintiff is mistaken about whether the claim actually falls within supplemental jurisdiction. 1. Tolling provision constitutional 483. In an action against a county, the tolling provision constitutionally directed that state law claims could be filed in state court after the limitations period otherwise would have run. The Supreme Court rejected the contention that tolling interfered with the state's sovereign authority to determine the extent to which its political subdivisions are subject to suit. and ruled that Section 1367D is a legitimate provision in light of Congress's power to establish lower federal courts. Jinks v. Richland County, 538 U.S. 456 2003. A. Distinguish 11th Amendment cases. The 11th Amendment is an explicit limitation on federal jurisdiction to entertain claims based on state law against states themselves, and Congress did not intend Section 1367D to apply to dismissals on 11th Amendment grounds. Rager v. Regents of the University of Minnesota, 534 U.S. 533 22. B. Voluntary dismissal of claim within original jurisdiction. If a claim asserted under supplemental jurisdiction is dismissed, the tolling provision will also apply to any claim that was properly within federal jurisdiction that plaintiff dismisses along with the supplemental claim. Rationale: if plaintiff prefers to combine all the claims in state court, limitations should not be an obstacle. E. Removal. 1. Introduction 484. Removal allows a defendant to shift a case from state court to federal court when the plaintiff has chosen to sue in state court. Although there is no mention of removal jurisdiction in the Constitution, some form of removal jurisdiction has existed since the federal court system was created by the first Congress. 2. Grounds for removal 485. In general, if the plaintiff files an action in state court but could originally have filed in federal court, the defendant can remove the action to the federal court. 28 U.S.C. 1441A. Note that there are exceptions to this rule, e.g., a defendant who is a citizen of the state in which the federal court is located cannot remove to state court. A. Federal Question 486. If the plaintiff's state court complaint raises a federal question, the defendant may remove. 1. Federal defenses not considered 487. The well-pleaded complaint rule applies in the removal situation. Thus, the fact that the defendant has raised a federal defense to the plaintiff's state law claim is not sufficient to support removal. Oklahoma Tax Commission v. Graham, 489 U.S. 838 1989. 2. Federal counterclaim not considered 488. The fact that the defendant has interposed a counterclaim asserting a federal claim does not provide a basis for removal on federal question grounds. Holmes Group v. Vornado Air Circulation Systems, Inc., Supra, 423. 3. Plaintiff omits federal claim 489. If the plaintiff chooses not to assert a possible federal claim, the defendant may not remove the case by citing the unasserted claim. A. Amendment to assert federal claim 490. If after filing in state court, the plaintiff amends the complaint to assert a federal claim, the defendant can then remove the case. Note that if the plaintiff does not amend the complaint, res judicata may bar assertion of the federal claim in a later action. B. Exception complete preemption 491. If federal law completely preempts state law on the matter and converts the plaintiff's claim into one of federal law, that satisfies the well-pleaded complaint requirement and makes the case removable. Metropolitan Life Insurance Co. v. Taylor, Supra, 426. 4. Effect of Supplemental Jurisdiction Statute 492. The Supreme Court has stated that the Supplemental Jurisdiction Statute 28 U.S.C. 10367 applies with equal force to cases removed to federal court as to cases initially filed there. City of Chicago v. International College of Surgeons, Supra, 415. Under the Supplemental Jurisdiction Statute, any case in which a federal claim is asserted in state court should be removable even though it includes defendants against whom only state law claims are asserted, as long as the claims against these defendants form part of the same federal constitutional case. 5. Effect of 11th Amendment Immunity 493. If a state is a defendant and joins in removing a federal question case that includes claims barred by the 11th Amendment which limits federal court jurisdiction over many private claims against state governments, see Federal Court Summary, The federal court may not hear the barred claims, but it still has jurisdiction over the remaining claims against the non-state parties. Wisconsin Department of Corrections v. Schacht, 524 U.S. 381 1998. B. Diversity of Citizenship 494. If the plaintiff could have filed the action in federal court using diversity of citizenship jurisdiction, the defendant may remove the case to federal court. Note that the complete diversity requirement applies in this situation. 1. Local Defendant 495. However, such removal is not permitted if any defendant is a citizen of the state in which the action is brought. 28 U.S.C. 1441b rationale. Since diversity jurisdiction is designed to protect against local prejudice, there is no reason to invoke it on behalf of a local party. Compare, a local plaintiff can file an action in federal court invoking diversity jurisdiction. A. Exception Class Action Fairness Act 496. In class action claims based on state law that could have been filed originally in federal court pursuant to the Class Action Fairness Act, a defendant who is a citizen of the state in which the action is filed may remove to federal court. 28 U.S.C. 453b. 2. Fictitious defendants 497. If the plaintiff has named fictitious John Doe defendants in the complaint, they are disregarded for purposes of determining whether there is complete diversity in cases that are removed from state to federal court. 28 U.S.C. 441a. Note that the effect of naming a John Doe defendant in a case originally filed in federal court is uncertain. See Supra 347. 3. Fraudulent Joinder 498. To prevent the defendant from removing the case to federal court, a plaintiff might join a defendant who is a resident of the state the plaintiff lives in or who otherwise would destroy diversity jurisdiction. If the plaintiff joins such a defendant and there really is no basis for the claim against that non-diverse party, the presence of that defendant will not defeat removal. 4. Jurisdictional Amount 499. The jurisdictional amount requirement applies to cases removed on grounds of diversity. See Supra 367 et seq. It has been held that the plaintiff can prevent removal by suing in state court for less than the jurisdictional amount, even though the claim could be for a larger sum. Freidenberg v. Walmart Stores, Inc., 397 F. Sup. 2D 7060. Me. 25. C. Separate and Independent Federal Claim 500. A defendant sued on a separate and independent claim or cause of action within federal question jurisdiction may remove, even if the plaintiff has joined non-removable claims. 28 U.S.C. 1441c. For example, a defendant sued for breach of contract and an unrelated violation of federal anti-discrimination laws can remove the case to federal court. Rationale: such removal protects the defendant's right of removal of a federal claim so that the plaintiff cannot prevent removal by joining a wholly unrelated claim. 1. Entire action removed 501. Where the separate and independent claim requirement is satisfied, the federal court may retain jurisdiction over otherwise non-removable claims or remand them to state court. A. Criticism: the retention of claims not otherwise within federal jurisdiction is anomalous. The court should retain jurisdiction over state claims only if the interests of efficiency dictate, i.e., where the claims are part of one constitutional case. Here, the case qualifies for removal precisely because the federal claim and state law claim are unrelated, separate and independent claims. 2. Limitation to federal question claims 502. Prior to 1990, Section 1441c allowed removal of separate and independent claims in diversity cases as well as in federal question cases. But the Supreme Court narrowly construed the power to remove such diversity cases. See, e.g., American Fire and Casualty Co. v. Finn, Supra, 288. Most cases removed on diversity grounds involved state law claims against some diverse and some non-diverse defendants. but few claims qualified for removal because state procedural rules typically allowed joinder of parties only if there was some relationship between the claims asserted, thus making the presence of a separate and independent claim unlikely. In 1990, Congress amended Section 1E441C to limit removal of cases with separate and independent claims to those involving a federal question. A. Possible constitutional problems 503. Recall that the federal courts are courts of limited jurisdiction. Because they have jurisdiction over cases and not merely issues, they can hear claims related to a case that otherwise would be outside the court's jurisdiction, but they may not hear unrelated claims absent a jurisdictional ground. See Supra 436. Recall also that the Supplemental Jurisdiction Statute 28 U.S.C. 1D367 gives the federal courts power to hear all claims that form part of the same case or controversy. See Supra 456-460. Such claims would seemingly be removable under Sections A and B of the removal statute. Thus, Section C either has no useful function or it purports to expand federal court jurisdiction beyond what is constitutionally permissible. B. Power to remand matters as to which state law predominates 504. The district court has discretion to remand all matters in which state law predominates. Whether this gives the district court power to remand the federal claim as well is unsettled. Compare Eastis v. Bell Creameries, LP 97 F3D 104th Sir. 1996 asserting that courts have, overwhelmingly, held that remand of the entire action is allowed, with Baker v. Kingsley 387 F3D 629 7th Sir. 24. It is an abuse of discretion for a district court to remand a federal claim that is properly before it, and Borough of West Mifflin v. Lancaster 45 F3D 783D Sir. 1995 discretion to remand under 1E441C applies only to claims based on state law. D. Special Removal Statutes 505. In certain cases, special removal statutes apply. For example, when a state court defendant in a civil or criminal case cannot adequately protect her federal civil rights regarding racial equality in state court, she may remove to federal court. 28 U.S.C. 1E443 also. Suits against federal officers sued for acts performed under color of office are removable. 28 U.S.C. 1D442 Additionally, actions that could have been brought in federal court under the Multiparty, Multiforum Trial Jurisdiction Act C. Supra 323 may be removed to federal court without regard to whether the defendant is a citizen of the state in which the action is brought, and different timing requirements may apply. 28 U.S.C. 1E369, 1T441E. 1. Distinguish All Writs Act 506. The All Writs Act provides that a federal court may issue any lawful writ necessary to aid its jurisdiction. However, this does not give a federal court authority for removal of a state court action that allegedly frustrates orders the federal court had previously issued. Syngenta Crop Protection, Inc. v. Henson, 537 U.S. 2822 state court case instituted in violation of the terms of a settlement in a prior federal court case could not be removed under All Writs Act. E. Removal forbidden in employment injury cases 507. Suits brought in state court against a railroad under the Federal Employers Liability Act (FELA) or under state workers' compensation laws are not removable. 28 U.S.C. 18445. The rationale for this limitation is to allow injured workers to pick the court in which they wish to have their claims decided. 1. Distinguish Fair Labor Standards Act 508. The Fair Labor Standards Act, which says that an action asserting a violation of its provisions may be maintained in either a state or federal court, does not guarantee a worker who sues in state court that the suit will remain there. A defendant is denied leave to remove only when a statute expressly forbids removal. Brewer v. Jim's Concrete of Brevard, Inc., 538 U.S. 691-23. F. Removal under the Class Action Fairness Act 509. Class actions making claims based on state law that could have been filed originally in federal court pursuant to the Class Action Fairness Act may be removed to federal court if filed in state court. 28 U.S.C. 14453. 3. Procedure for removal 510. A defendant seeking removal must file a notice setting forth the facts supporting removal in the federal district court and division within which the action is pending. A copy of the notice should be sent to the other parties and to the state court. A. Only defendant can remove 511. Only the defendant has the power to seek removal. Even if the defendant asserts a federal claim as a counterclaim, the plaintiff may not remove. Shamrock Oil Co. v. Sheets 313 U.S. 11941. B. All defendants must join 512. All defendants who have been served with process must join in the notice of removal. Chicago, Rock Island and Pacific Railway v. Martin 178 U.S. 245-19. However, when the ground for removal is a separate and independent claim, only the defendant against whom this claim is asserted need seek the removal. 1. Exception Class Action Fairness Act 513. Class actions governed by the Class Action Fairness Act may be removed by a single defendant without the consent of the other defendants. 28 U.S.C. 14453b. C. Timing 514. The notice of removal must be filed within 30 days after the time the case becomes removable. If the action is removable as filed, the 30 days begin running from the time process is served on the defendant. If the action becomes removable only due to some later development, e.g., amendment to add a federal claim to the complaint or dismissal of non-diverse defendants, the 30 days begin running from that point. However, removal on grounds of diversity is not allowed more than 1 year after the commencement of the action. 28 U.S.C. 14446b. But note, when removal is permitted under the Class Action Fairness Act, the 1-year limitation does not apply. 28 U.S.C. 14453b. 1. Service of process required to trigger running of time limit for removal 515. Section 14446b says that the time to remove starts when defendant receives a copy of the complaint through service or otherwise. However, the Supreme Court has held that the 30 days do not begin to run until the defendant is formally served. Murphy Brothers, Inc. v. Machete Pipe Stringing, Inc. 526 U.S. 344 1999. 2. Grounds for removal obscured on Complaint 516. In some situations, the lower courts have found that the time for removal does not start running until the defendant learns more about the claim so as to be able to determine that it is removable. See Lovern v. General Motors Corp. 121 F3D 164th Sir. 1997 Citizenship of Plaintiff, not known until discovery obtained. And see Huffman v. Saul Holdings, Limited, 194 F3D 172 10th Sir. 1999 time to remove did not start running until deposition testimony showed that claim exceeded jurisdictional minimum. 3. Exception Multiparty, Multiforum Actions 517. In multiparty, multiforum actions that could have been brought in federal court under 28 U.S.C. Section 1E369C Supra, different timing requirements may apply. Notice of removal may be filed within 30 days after a defendant in state court becomes a party to an action in federal court that falls under the statute. However, with leave of the district court, notice of removal may also be filed at a later date. Additionally, the 1-year time limit for removal does not apply to these actions. 28 U.S.C. 14441e. D. Effect of removal 518. The case is considered to be removed as soon as the notice of removal is filed and served. After that, the state court may take no further action on the case. The remedy for improper removal is to seek a remand to state court. See Infra 520-526. E. State Court Lack of Subject Matter Jurisdiction 519. The federal court has jurisdiction over an otherwise properly removed action, even if the state court lacked jurisdiction over the claim. 28 U.S.C. 14441F Section 1E441F, however, applies only to cases removed under this section. For cases removed under other provisions, removal jurisdiction is derivative. Federal court lacks jurisdiction if the state court from which the case was removed also lacked jurisdiction. Thus, the rare non-Section 1E441 removal of an exclusive federal jurisdiction case improperly filed in state court is impermissible. The case must, absurdly, be remanded to state court for dismissal and refiling in federal court. See, e.g., Barnaby v. Quintos, 410F, Sup. 2D 142 SDNY, 2005. Example: plaintiff sues defendant in state court for violation of federal antitrust laws, a claim over which there is exclusive federal jurisdiction. Defendant may remove to federal court under Section 14441. 4. Remand. A. Improper removal 520. If the case was improperly removed, the federal court should remand it to state court. 28 U.S.C. 1E447C. Remand is required whenever the court determines that removal was improper, unless final judgment has been entered. 1. Jurisdictional defect cured before final judgment entered 521. If there was a jurisdictional defect at the time of removal, so that the case should have been remanded but was not, and the defect is cured before final judgment is entered, interests of finality, efficiency, and economy justify disregarding that defect on appellate review, even if the plaintiff timely moved to remand and the district court erroneously denied that motion. Caterpillar, Inc. v. Lewis, 519 U.S. 61 1996. Non-diverse defendant dismissed after motion to remand was denied but before trial. 2. Time limit for motion to remand on ground other than lack of subject matter jurisdiction 522. If the ground for the motion to remand is something other than lack of subject matter jurisdiction, e.g., a defect in removal procedure, the motion must be made within 30 days after the notice of removal is filed. 28 U.S.C. 14447C. C. Supplemental claims after dismissal of federal claims 523. When a court would otherwise dismiss the supplemental claims after disposing of the federal claims, see Supra 477, it may instead remand them to state court. Carnegie Mellon University v. Cohill, 484 U.S. 343 1988. C. Other grounds for remand 524. The Supreme Court has indicated that remand is usually not allowed where a case was properly removed. Thermtron Products, Inc. v. Hermansdorfer, 423 U.S. 336 1976. Remand improper when based on expectation that there would be greater delay in obtaining a trial date in federal court than in state court. 1. Distinguish addition of non-diverse defendants 525. Under 28 U.S.C. Section 1E447I, if the plaintiff seeks to add additional defendants whose addition would destroy subject matter jurisdiction, the court may permit joinder and remand. D. Appellate Review 526. An order remanding a case to state court on grounds of lack of subject matter jurisdiction or a defect in removal procedure is not reviewable on appeal or otherwise. 28 U.S.C. 14447D. Things Remembered, Inc. v. Petrarca, 516 U.S. 124 1996. However, this prohibition is not as unqualified as it seems. The Supreme Court has upheld review via mandamus, a writ procedure seeking an order from a superior court to an inferior court to perform some act when a district court openly remanded on a ground not authorized by the statute. Thermtron Products, Inc. v. Hermansdorfer, Supra. In addition, the Supreme Court has upheld review of a remand order based on abstention principles under the collateral order doctrine. Quackenbush v. Allstate Insurance Co., 517 U.S. 706/1996. See Infra 2096-2212 for a discussion of abstention. See Federal Court's summary. 1. Distinguish remand motion erroneously denied. If a motion to remand is erroneously denied, the plaintiff need not attempt to obtain interlocutory review to preserve the error for review after final judgment. Although denial of the motion to remand will not justify reversal if the jurisdictional defect is cured before entry of final judgment. Caterpillar, Inc. v. Lewis, Supra, 521. 2. Appellate review under Class Action Fairness Act 527. In class actions making claims based on state law that could have been filed originally in federal court pursuant to the Class Action Fairness Act, see discussion of Act, Supra, 345. The Court of Appeals has discretion to accept an appeal from an order granting or denying a remand, provided that the application for review is made within 7 days of entry of the order. 28 U.S.C. 14453 C1. The appellate court is directed to complete its review within 60 days, although extensions are allowed under some circumstances. 28 U.S.C. 14453 C2, 3. E. Attorney's fees on remand 528. Under 28 U.S.C. Section 1E447C, the court has discretion to award attorney's fees to the party seeking remand. Martin v. Franklin Capital Corp., 546 U.S., 132 2005. 28 U.S.C. 14447C does not establish a presumption against or in favor of awarding attorney's fees. That decision is left to the discretion of the district court, which should not ordinarily award fees when the removing party had an objectively reasonable basis for removal. 5. No reverse removal 529. There is presently no method by which a defendant can remove a case originally filed in federal court to state court. A. Distinguish abstention 530. Federal courts may, however, decline to proceed in certain situations where abstention is proper. This may be due to the presence of an uncertain issue of state law pertinent to a federal constitutional claim, or due to deference to litigation already pending in state court. For details on abstention, see Federal Court Summary.